Yeah, so we definitely really appreciate everybody coming out today, and for anyone who would be listening to this or watching this or anything. My name is Adnan Syed, and this is my mom, Shameen. This is my younger brother, Yusuf. And I was saying, a lot of people ask about my dad. My dad, his health is not that great right now, so he's upstairs. He wouldn't physically be able to attend this right now, but we really appreciate everybody coming out. More importantly, we appreciate everybody's support over the past 24 years. You know, back in 1999, I was a 17-year-old high school student, and I was arrested and charged with a crime I didn't commit. A very close and dear friend of mine named Hae Lee, she was murdered, and I was ultimately charged and taken to trial and wrongfully convicted of that crime. And I would go on to I was sentenced to life in prison, and I would spend the next almost 24 years in prison. And it wasn't until recently, 1 year ago today, that I was actually released. So for my mom and for my brother and my dad, we just always wanted to say thank you to every single person who's always just expressed support and encouragement and showed kindness and love to our family throughout this difficult time. Just to briefly say, I was going to go through a presentation briefly. We wanted to present two pieces of information that have recently come to light that we don't feel that the public knows about, and more importantly, the Attorney General, Mr. Anthony Brown, he doesn't know about. We know there's been a lot of coverage over this case over the years, and we appreciate the fact that so many people have come forward to investigate this case and to use their resources to find out who's responsible for Hae's murder. For all these years, not just me proving my innocence, but that's been one of our biggest goals. You know, we respect how much Hae's family has suffered because we know how much our family has suffered, and not just trying to prove that I'm innocent and to make it back home to my family, but to find justice for Hae and her family. That's always been one of our primary concerns as a family. So I wanted to do a brief presentation, and part of the presentation includes a public request to Mr. Anthony Brown. He's the new Attorney General. Over the past year, we have a lot of respect for Mr. Anthony Brown. We know that throughout his career as a Lieutenant Governor, as the representative from Maryland, and recently he's really always taken a stand up for the rights for Maryland families. And we're asking that, Mr. Brown, if you could please open an investigation into this case, particularly regarding these two new pieces of information, to essentially understand how our rights as a family have been violated. And we're really just asking for his assistance in this matter. So I wanted to do a brief presentation, and then I'll take questions afterwards. And I apologize in advance. The presentation is kind of lengthy. The reason why it's lengthy is because we wanted to actually use documentation, whether it was court documentation, as transcripts, or if it was letters back and forth to the judge, or if it was affidavits. We wanted to present the actual document so people could see for themselves, and they could make their own determination. So, again, I appreciate everybody being patient. Should be coming up. Yeah, so here it is. Sorry for the delay. So one of the first things we wanted to talk about was regards to the fact that over the past 24 years, while I was released last year, and the Baltimore City Circuit Court Judge, Melissa Finn, she vacated my conviction, issuing an opinion finding that due to a Brady violation in my case, I was denied a fair trial. Judge Finn, she wasn't the first judge in the past 24 years to issue an opinion vacating my conviction and to state that I should receive a new trial. She wasn't the second judge, she wasn't the third judge, she wasn't the fourth judge, she wasn't the fifth judge, she wasn't even the sixth judge that did it. Judge Finn was the seventh judge in the past 24 years who's reviewed the case file, listened to arguments, or reviewed motions, and issued an opinion or supported an opinion, making a finding to vacate my conviction and that I did not receive a fair trial. So the very first time that it happened was in 2016, and it was Judge Welch. The second time after that was in 2018, and it was in the Court of Special Appeals of Maryland, which is now the Appellate Court of Maryland, and it was Chief Judge Woodward and Judge Wright. And in 2019, the Court of Appeals of Maryland, Judge Michelle Houghton, Judge Atkins, and Chief Judge Barbera, Judge Houghton had written a dissent opinion. And in this opinion, the Chief Judge and Judge Atkins had joined her in making a finding that my conviction should have been vacated because I did not receive a fair trial. And then come to 2022, where in the Baltimore City Circuit Court, Judge Finn, she made a finding. So just to kind of like say it off the top, is that Judge Finn is not the only judge who's made a finding to vacate my conviction. It's actually happened with 7 different judges who've issued these opinions. So I want to go through the language real briefly because their language describes the case as they saw it after reviewing the transcripts, after reviewing the file, listening to oral arguments from both sides. And if you look, and I just highlighted some portions, but these comments come from their actual opinion, so these are their exact words. So in 2016, Judge Welch, he wrote in his opinion, in fact, the state presented a relatively weak theory as to the time of the murder because the state relied upon inconsistent facts to support its theory. In the Court of Special Appeals of Maryland in 2018, Judge Woodward, he wrote, and he was joined by Judge Wright, in stating that with little forensic evidence, the case was largely dependent on witness testimony. And testimony of these witnesses often conflicted with the state's corroborating evidence, i.e. the cell phone records and the cell tower location testimony by the expert, Abe Aronowitz. And he continues, Wild's own testimony conflicted with the state's timeline of the murder. No eyewitness testimony placed Syed and Hae together leaving school or at the Best Buy parking lot. And at trial, the state adduced no direct evidence of the identity of the person who killed Hae. So it continues with the dissent opinion written by Judge Houghton in the Court of Appeals of Maryland, now the Maryland Supreme Court. And she was joined by Chief Judge Barbera and Judge Atkins. And she wrote, in the present case, the state offered no eyewitness testimony or any other evidence for that matter, putting Mr. Syed with Miss Lee during the time of her death, much less any direct evidence that Mr. Syed caused the death of Miss Lee. And the state offered no direct evidence establishing that Mr. Syed caused the death of Miss Lee, and its case was largely dependent on witness testimony, which the state readily admitted was conflicting and problematic. So I do understand that this case has generated and has received a tremendous amount of attention over the past 6 or 7 years or so. And one of the things that has generated so much attention about this case is that people have come to understand what prosecutorial misconduct is. And the definition of prosecutorial misconduct, like in layman's terms, is essentially when the prosecutor behaves unethically in not disclosing evidence or presenting false testimony or false information to the court in order to sway the court or to sway the jury. So many people have learned about prosecutorial misconduct through studying this case and understanding everything that happened. So I just want to briefly talk about the history of prosecutorial misconduct in this case. So it began in the very beginning. So one of the very first hearings that any defendant in America will go to, they'll go to what's known as a bail hearing. So initially the process is a person will be indicted, then there's an arraignment, and the bail hearing is where any and every defendant has an opportunity to convince the court that they are not a risk to be returned to society in order to prepare for their trial. So it's the very first hearing. It's the very first time I can remember being in court with my family, but I was incarcerated. I was in handcuffs or in shackles or whatever. And just to paint the picture of this bail hearing, this is back in 1999. I'm a 17-year-old kid. My mom, my dad is there. My older brother's there. And we were fortunate to have the support of our community. And when I say our community, we belong to a local Muslim community that has hundreds, if not thousands, of families. At the time, it was smaller. But we were so fortunate that so many members of this community, they came to this bail hearing in support of my family. They believed that I was innocent. And they didn't just attend, but they were willing to donate financial resources to pay for bail. My family, they were not people who have a lot of means or money. And several of these families actually offered to put their own houses up as collateral. And this is all documented if someone was to go through the bail transcripts. So this is to kind of paint the picture of what was going on at this bail hearing. So it was the first time in court. And the prosecutor at the time, her name was Vicki Walsh. So I just want to read off this part right here. So at the bail hearing in 1999, State's Attorney Vicki Walsh, she made prejudicial arguments about me being a flight risk because of my Pakistani descent. Additional arguments were made that the support of this community meant that I had access to people and resources which would help me flee the country. Prosecutor Walsh argued to the court that a State Department official told her there was a pattern of young Pakistani men committing murder and fleeing the country. The judge would ultimately deny me bail. So subsequently, my attorney contacted that State Department official and forwarded a transcript of the bail hearing. And shortly afterwards, the prosecutor, Ms. Walsh, she wrote a letter to the court admitting that the official did not say those things to her, and she was removed from the case. And Judge Welch would go on in 2016 to describe those remarks as both xenophobic and egregious in nature. So like I said, I want to present the actual transcript of what she said so you can see it for yourself. So this is the bail hearing from March 31st, 1999. And it begins, the highlighted portion. This is Ms. Vicky Walsh speaking. Your Honor, I spoke with Mr. Larry Marshall. He is from the Office of International Affairs, which is a segment of the Justice Department. He is a senior legal advisor there. He is an expert on the relationship between the United States of America and Pakistan. What he indicated to me is that while there is a treaty in place for the return of flight individuals who flee to Pakistan, that the United States of America has never been successful in a murder case. And it continues, and he cited that there is a pattern in the United States of America where young Pakistani males have been jilted, have committed murder, and have fled to Pakistan, and we have been unable to extradite them back. He gave me a specific instance that's occurring, and that's pending in Chicago, where the factual pattern is frighteningly similar. So she continues, Your Honor, the fact that the defendant has strong support from the community, that is what makes him unique in this case. He is unique because he has limitless resources. He has the resources of his entire community here. Our investigation reveals that he can tap resources from Pakistan as well. It's our position, Your Honor, that if you issue a bail because of his unlimited resources, then you are issuing him a passport under these circumstances to flee the country. And she concludes her argument by saying, we're asking you to take all those facts into consideration, Your Honor, and most importantly, what Mr. Marshall has indicated about the flight risk. So mind you, the people in the court are moms and dads and parents and grandparents, small children there, some of my school classmates. These are the people that she's referring to have the resources to help me flee the country. Someone who was born in America, I don't speak any other language than English. I've only been to Pakistan once as a small child. And more importantly, this is a case where I'm innocent. I had absolutely nothing to do with the murder of Hae. And ever since the very beginning, all we've ever wanted to do is to prove that I'm innocent, and more importantly, or just as importantly or more importantly, to get justice for Hae and her family. So she makes these comments, and at the time, my attorney, he reaches out to Mr. Larry Marshall, because now she's saying a State Department official has told her these things. When she reaches out to Mr. Larry Marshall, he doesn't speak to my lawyer. Mr. Larry Marshall has a conversation with Ms. Walsh. And Ms. Walsh, sometime later, is forced to write this letter to the courts. So she writes this letter, it's April 21st, 1999. Dear Judge Mitchell, he was the judge who handled the bail hearing. And she writes, Mr. Harry Marshall, the senior legal advisor, Office of International Affairs, he called me on April 14th, 1999. Mr. Colbert forwarded the transcript of Syed's habeas corpus hearing to Mr. Marshall. Mr. Colbert was my attorney at the time. Mr. Marshall then contacted me to express a concern that two of the statements I made to the court were the product of information that I misconstrued during our conversation. The first statement concerns the comment regarding the pattern of young students who had been jilted, committed murder, and fled to Pakistan. Mr. Marshall advises there is not a pattern. The second comment involves the reference to the pending Chicago case. That case parallels Syed's case, only that it involves a Pakistani man charged with murder. So she has to completely, essentially recant what she said. And the idea that she misconstrued this, I think a lot of people know that that's not an accurate description of what happened. And Judge Welch, he would talk about this in 2016. So 17 years later, Judge Welch would comment on this. And Judge Welch, in an opinion he issued, he would write in a footnote, the circuit court finds that petitioner's March 31st, 1999 bail hearing was fundamentally flawed by the state's argument, which was xenophobic and a gendered cultural stereotype of Pakistani men. That such an argument was made without any basis in fact and potentially considered by the judicial officer in determining flight risk is so egregious that it negates the circuit court giving the bail decision any weight in this matter. So I bring this up to say this. Ms. Walsh, she makes this false argument. And one could argue it's a pretty deliberate argument. And when this information comes to light, that it was a false argument, I'm in jail. The impact of her false argument was never corrected. The judge took this into consideration. He issues his decision as bail. Once it comes out, there's no accountability. Nothing changes. I'm still in jail waiting for trial. And what ends up happening is that Ms. Walsh is then removed from the case. So from the very beginning of my case, from the very outset, prosecutorial misconduct was present. And the reason why I'm presenting these documents again is so that people can see it for themselves. So Ms. Walsh was replaced in the case, and she was replaced by 2 additional prosecutors, Mr. Kevin Urich and Ms. Kathleen Murphy. So they were both assistant state's attorneys at the time. So these 2, they took on the case, and I think people are familiar if they followed the case. We ended up having 2 trials. The first trial was declared a mistrial because the judge at that time called, in a series of exchanges, referred to my lawyer as a liar. When the judge called my lawyer a liar, the jury had submitted a note saying, "We heard you call the defendant's attorney a liar." Essentially, like, what do we do about that? And the judge ended up declaring a mistrial. So we ended up having a second trial. I was ultimately convicted, and I was sentenced to life in prison. And we would spend the next almost 24 years just trying as best as we can. We were so fortunate to have supporters who would donate money, they would donate resources, they would donate their time. We had a really incredibly wonderful lawyer named Justin Brown for 10 years. We're fortunate to have a really amazing attorney now named Erica Suter. And we've only been able to retain these attorneys through the goodness of their hearts and through the goodness of people who have been donating time and energy and resources to help us retain them. So over the past 24 years, we had a chance to file appeals. And what ends up happening in these appeals, which is characteristic of many wrongful conviction cases, if not all of them, what happens in trial, it takes 10, 15, 20 years for the truth to come out about what took place behind the scenes. So I wanted to move on to one of the appeals that we filed was in 2012. And in 2010, we filed what's called a post-conviction petition. And we were seeking to present to the court an alibi witness that I had that had never testified at trial. So I'm going to take a moment to read through this. So the state's theory at trial was that the crime took place on January 13th, 1999, between 2:15 p.m. and 2:36 p.m. So myself and Hae, we were both high school students, and this alibi witness also was a high school, so she's one of our classmates. So the school at the time ended at 2:15 p.m. So after my arrest, a fellow student named Asia McLean, she wrote me 2 letters while I'm housed in the Baltimore City Detention Center, stating that she remembered being in the public library and seeing me there on January 13th, 1999. So my trial attorney at the time, she never contacted Asia McLean. I had given her the information, and for whatever reason, she had never contacted Asia McLean. After my conviction in 2000, Asia McLean provided a sworn affidavit stating that she saw me in the library on January 13th, 1999. And she stated that we had a brief conversation, and she left around 2:40 p.m., and that I was still in the library when she left. So in 2010, we filed for this post-conviction relief, and we're seeking to present to the post-conviction court Asia McLean's testimony. That we had the hearing in 2012. So throughout this time, we've been unable to contact Asia McLean. Never heard from her, never talked to her, not one single time. My attorney, he took various efforts to try to reach out to her. So she was not at the hearing. So we moved forward at the hearing presenting the 2 sets of documents, the letters that she wrote me when I first was arrested, and the affidavit that she wrote about a year later after my trial. So it's important to remember those are 2 separate documents. So when we get to the hearing, so Kathleen Murphy, who was one of the prosecutors along with Kevin Urich, she's at this hearing. So it's almost 13 years later. She's working in the state's attorney's office. So she's there to defend the conviction that she and Kevin Urich secured. So Kevin Urich, he's also there. And Kevin Urich is on the stand. So what Kevin Urich testifies to was just a shock to all of us. Kevin Urich testified that Asia McLean had contacted him and said that she felt pressured by my family to write the affidavit that she had written back in 2000. So the judge would ultimately deny our motion, because now here you have a prosecutor in court stating that this witness contacted him and saying that she felt pressured into writing the affidavit. It's important to remember that. So the podcast Serial was released in 2014. And in 2015, in response to Serial, Kevin Urick, he does an interview with an online publication called The Intercept. So in this interview, he now claims that Asia McClain had told him that she felt pressured by my family, by my mom, by my dad, by my little brother, to write the letters she sent me back in 1999. So now Kevin Urick has conflated his lies. Initially at this post-conviction hearing in 2012, he said that Asia McClain told him she felt pressured by my family to write the letters that she wrote me. To write the affidavit that she wrote me. And now in this Intercept interview, he's saying that Asia McClain told him that she felt pressured by my mom, by my dad, by my younger brother to write the letters that she wrote me. So again, he's conflated his lies. So Asia McClain, unbeknownst to any of us, she's in another state somewhere across the country. She hears the audio of Kevin Urick. She listens to Serial, and for the first time ever, she hears the audio of Kevin Urick testifying falsely about their conversation. So she retains an attorney on her own, and she submits an affidavit to the court. And she affirms seeing me after school in the library on January 13th, 1999, that we had a conversation and that she left around 2:40 p.m., leaving me in the library. And she also stated that Kevin Urick discouraged her from attending the 2012 post-conviction hearing. So she describes their conversation. So the case ended up being reopened, which is extremely rare. And you can ask any defense attorney or anyone who follows cases. It's extremely rare for an appellate court to reopen a case so far into a person's conviction. So the case is reopened and Asia McClain is allowed to testify. And she testifies at length. Many of you may or may not have seen it or have been there. And this is subsequent to her testimony, opinions were issued by different judges in 2018 and in 2019 that found her testimony both credible and significant enough to warrant my conviction being vacated. So I want to go briefly through exactly what Kevin Urick said. So this is from the 2012 post-conviction hearing. This is actual trial transcript. So the person asking the questions is Miss Murphy. The person on the stand is Kevin Urick. So Miss Murphy asked Kevin Urick, Mr. Urick, how did you learn that the defendant had filed this petition? And Kevin Urick answers, a young lady named Asia called me. Next, Miss Murphy asks him, and what did she say? And Kevin Urick responds, she was concerned because she was being asked questions about an affidavit she had written back at the time of the trial. She told me she had only written it because she was getting pressure from the family. And she basically wrote it to please them and to get them off her back. So this is his trial. This is his post-conviction testimony. Now we move to the interview he does with The Intercept. This is in response to Serial. So Kevin Urick is being asked a question by the reporter, and Kevin Urick Kevin Urick says, Asia contacted me before the post-conviction hearing. She got my number and called me and expressed to me a great deal of concern about whether or not she would have to testify at the post-conviction hearing. She told me she was under a lot of pressure from Adnan's family. My mom, my dad, that's my family, and my brother. And to get them off her back, she wrote him a couple of letters. The implication was that she was trying to appease them, and she didn't want to have to stick by it at that time. And I testified to that when I appeared in the post-conviction hearing. So this shows that he conflates his lies. Again, at the post-conviction hearing, he says that she was pressured to write the affidavit. Now in this interview, he says that she was pressured to write the letters. So, as I stated before, Asia McClain, she listens to Serial, she hears Kevin Urick's testimony, so she comes forward on her own accord. So it's important to remember this. Kevin Urick has lied about someone. This person comes forward with an affidavit to correct that lie and to prove that it was a lie. So Asia McClain, she comes forward, this is her affidavit, and she goes through the whole entire thing. I just want to skip to the second page where she specifically talks about her conversation with Kevin Urick. So if you look at point 26, I made telephone contact with one of the state prosecutors from the case, Kevin Urick. He told me there was no merit to any claims that Syed did not get a fair trial. Urick discussed the evidence of the case in a manner that seemed designed to get me to think Syed was guilty and that I should not bother participating in the case. by telling what I knew about January 13th, 1999. Urick convinced me into believing that I should not participate in any ongoing proceedings. I just want to repeat that one part. Urick convinced me into believing that I should not participate in any ongoing proceedings. And she continues, I never told Urick that I recanted my story or affidavit after January 13th, 1999. In addition, I did not write the March 1999 letters or the affidavit because of pressure from Syed's family. I did not write them to please Syed's family or to get them off my back. Again, my family is my mom, my dad, and my little brother. I wrote the affidavit because I wanted to provide the truth about what I remembered. So this is essentially, the affidavit that she provides. And it's important to know that she comes forward on her own. We never contacted her. We never spoke to her. Even to this day, our family has never even had a chance to say thank you to her just for coming forward. In a case where there was so much attention, in a case where she was only coming forward. She was doing what the authorities say do all the time. If you see something, if you have some information, come forward. And she was vilified for it. She was on the stand. She was cross-examined for hours. For hours. So I want to go to what two different courts have written in their opinions about her testimony. That they found it to be credible, they found her testimony to be compelling, and even more so, they found that her testimony would have changed the outcome of my initial trial. So the Court of Special Appeals of Maryland, they wrote, and this is in 2018. So again, this is the opinion written by Chief Judge Woodward and joined by Judge Wright. So the state even implicitly conceded the strength of McLean's testimony and its potential impact on the jury when it attempted to present a new timeline for the murder at the second hearing. Accordingly, in considering the totality of the evidence at Syed's trial, with the potential impact of McLean's alibi testimony, this court holds that there is a reasonable probability that but for trials counsel's deficient performance, the result of Syed's trial would have been different. So the Court of Appeals of Maryland, they issued a dissent opinion by Judge Houghton, joined by Chief Judge Barber and Judge Atkins, making a finding that my conviction should be vacated and that I should be granted a new trial. Now, it was a dissent opinion. So to read briefly what she said, not only does Ms. McLean's alibi address the most integral period of the time in the case, it presents direct and not merely circumstantial evidence of Mr. Syed's whereabouts during that time. Insofar as I could determine, no other evidence was offered by the state that would have refuted Ms. McLean's testimony and affidavit. The state offered no direct evidence establishing that Mr. Syed caused the death of Ms. Lee, and the case was largely dependent on witness testimony, which the state readily admitted was conflicting and problematic. On the other hand, Ms. McLean's alibi testimony would have been direct evidence from a disinterested witness that Mr. Syed was not in the same location as Ms. Lee at the time of her death. And she finishes, McLean's testimony, if believed by the trier of fact, would have made it impossible for Mr. Syed to have murdered Ms. Lee. So this is just the first example, and I just feel like it's important to remember, Kevin, again, I know I'm restating this again, Kevin Urick lies about a person, this person comes forward, provides an affidavit stating that it was a lie. And the second thing to remember is this is the beginning of a pattern of behavior. When Kevin Urick and Kathleen Murphy, they discourage a person from coming to a hearing, and then they weaponize that person's absence at that hearing to the ultimate detriment of our family and myself. And it only gets uncovered later on. So this was the first example of prosecutorial misconduct by Kevin Urick with regards to the alibi issue. Now we come to prosecutorial misconduct regarding the cell tower issue. So Abe Aronowitz, he was the state's cell tower expert at trial in 2000. He was called to verify cell phone location data based on cell tower data.
It just went out.
Oh, it just went out? Oh, I think you hit the... I'm sorry.
You want to plug it into this reel right here?
Do you know if you can
No, you should turn the TV on.
Oh, it's back on. I'm sorry, you guys. Yeah.
It's up to you.
Yeah.
All right. Okay. So I apologize, you guys, for that. Thank you too, Foz, for your help. So we come to the prosecutorial misconduct regarding the cell tower issue. So this was the second issue. And so just to repeat, sorry again, Abe Aronowitz was the state's cell tower expert at trial, witness at trial in 2000. He was called to verify the cell phone location based on cell tower data. So Kevin Urich, he withheld a very important piece of evidence from Mr. Aronowitz, a cover sheet from AT&T which contained a disclaimer that incoming calls were not reliable for location. This was very critical because the state relied heavily on using incoming calls to pinpoint locations that would buttress their theory. So in 2015, Mr. Aronowitz, he found out about the AT&T cover sheet and the disclaimer for the first time. He submitted an affidavit which stated how he should have been shown this document and that if he had seen it, it would have affected his testimony. So in 2016, Baltimore City Court Judge Welch, he issued an opinion vacating my conviction based on the cell tower issue. So I want to briefly just go through Mr. Aronowitz's affidavit. So at point number 2, he says, I was the state's expert witness with regard to cell tower technology. And just prior to my testimony in the courthouse, Urich presented me with a document. And since this appeared to have ordinary AT&T cell site data on it, I accepted it as it was presented. And to go to point 5, what Urich did not tell me or call my attention to in relation to Exhibit 31 was that AT&T had previously issued the disclaimer, stating that any incoming calls will not be considered reliable information for location. And he says, if I had been made aware of this disclaimer, it would have affected my testimony. And he says, I consider the existence of this disclaimer about incoming calls to have been critical information for me to address. I do not know why this information was not pointed out to me. So now we have a second example. And we know that there are lies of commission. There are also lies of omission. And one of the responsibilities of a prosecutor when we talk about prosecutorial misconduct is to disclose information not just to the defense, but to their own witnesses also, especially if it's an expert witness. An expert witness has a right, and the prosecutor has the obligation to disclose all documentation, whether it benefits the state's theory or if it hurts the state's theory. It's a very critical part. And so this is the second time now where Mr. Urich has misled or committed a lie by omission in this trial, and a person has found out about it years later and submitted an affidavit to correct this lie, and a judge would issue a ruling finding that my conviction should be vacated and that I was granted a new trial. So this is the second time this has happened. So now we come to, I guess you could say, the third time now. So prosecutorial misconduct regarding the Brady violation. So many of you may or may not know, I was actually released. A motion to vacate was filed, and the Baltimore City Circuit Court made a ruling that based on several issues in the case, but the main issue was a Brady violation. A Brady violation is information that a prosecutor has that is exculpatory of the defendant or mitigating to the defendant, and it must be turned over. And if it's not turned over, it's considered a Brady violation, and a judge can make a ruling that if this information had been turned over, it could or would have changed the outcome of the trial. So in September of 2022, Baltimore City Circuit Court Judge Finn vacated my conviction and granted a new trial based upon a Brady violation. She determined the trial prosecutor in my case committed a Brady violation by not disclosing exculpatory material to the defense. So at issue was a note written by Kevin Urich. This note contained information that someone else had threatened to kill Hae. And this note was never turned over to the defense in 1999, nor in the 23 years of appeals that ensued. So it's important to remember this. when Serial came out and multiple other podcasts came out and documentaries, this case generated a tremendous amount of attention. And multiple people, journalists, other attorneys, people who were just interested in this case, they cared about justice for Hae. They wanted to know who the person or persons responsible for committing this crime. And they also they came to care about my family. They came to believe that I was innocent, or at the very least didn't have a fair trial. So people were filing Public Information Act requests, left and right. There are some reporters in here, I wouldn't be surprised if you guys had filed or if your organizations had filed them. And in all these years of filing of requests, people litigating to get information in this case, this note never came up. It was buried so deep in this file, and so what ends up happening is that I ended up being released, and in October of 2022, DNA testing was completed, and it yielded male DNA on very significant evidence that excluded me. So the charges were dismissed. So what ends up happening is that in November of 2022, just a month later, Kevin Urick, he leaked the note and a transcript of the note to a media outlet. Now this transcript is what he just created in November of 2022, or sometime recently. This transcript did not exist in the original file. So he describes the note as not referring to the person who threatened to kill Hae. Instead, he said it's referring to me. So this is seized upon by opposing parties in ongoing litigation to reinstate my conviction. And his lies are presented to the court in their motions. So I want to go briefly through. So this was the article published by a local newspaper, and this is the newspaper that he leaked this information to. So the headline is, "A decades-old note helped Adnan Syed get out of prison." The author says it was misinterpreted. So I'm sure people have read this article. So just to go briefly, it says, Baltimore prosecutors cited the note as newly discovered evidence when they asked a judge in September to toss out Syed's murder conviction. So this is the actual note. And if you look at the bottom, it says the name of the publication. Obtained a copy as well as a corresponding transcript from its author, Kevin Urick. So now he has verified that he's the person who gave this information to this publication. He also has created this corresponding transcript. So he confirms the authenticity of the note and his transcript, but he declines to comment. So he gives the note, he gives the transcript, but he doesn't say anything. He just goes on about his business. So this is the transcript that he created of a note from 23, 24 years ago. And at the very bottom in red, and I'm sorry it's small, he writes that he refers back to and replaces the proper noun, Adnan, its antecedent. And the he is saying he told her that he would make her disappear. He would kill her. So what ends up happening is that he writes in this note, he refers back to and replaces the proper noun, Adnan, as antecedent. Its antecedent, and Urick writes in a footnote of the transcript. So what ends up happening, once this note is published, opposing counsel who are seeking to reinstate my conviction, they seize upon this. And so now they present this as evidence to the court that, this Brady violation, it wasn't even a Brady violation. Look what Kevin Urick said. He's the person who wrote it. And look, here's this transcript that he created. So the note is subject to multiple interpretations. An assistant attorney general, this person's name, wrote the court last week. So this shows how what we know is that Kevin Urick, he has a pattern of committing prosecutorial misconduct and essentially getting caught. And specifically, in the history of him is that, and we demonstrated just twice, he'll lie about something or present false information. A person comes forward who is a source of that information to confirm that Kevin Urick lied and he misrepresented the facts to the court. Asia McClain did it in 2015. Abe Aronowitz did the same thing. He was misled by Kevin Urick. He came forward to provide an affidavit. And Kevin Urick, he would deliberately mislead the court to the detriment of our family. It would harm our family. And there's never been accountability. But now we have proof for the third time Kevin Urick has done the same thing again. He's lied. So the evidence proving Kevin Urick's prosecutorial misconduct regarding the Brady violation. So the source of that information in that note, 24 years later, has come forward and provided an affidavit affirming that, number one, the information in that note was not referring to me. Number two, the note was about an individual who threatened to kill Hae. Number 3, the individual was upset with Hae. And number 4, the individual stated he would make disappear. So this witness is has been described as a very credible, a hardworking professional, a parent and a spouse, and a well-respected member of their community. And this affidavit was given to a private investigator, and it's now in the custody of an attorney. So this is the 3rd time now that Kevin Yurick has lied in this case, has presented misleading evidence, harmed my family, harmed myself, prevented any justice for Hae and her family, and he's been caught. And a regular citizen who provides that information has to come forward and swear out an affidavit to prove that Kevin Yurick is lying. So the thing about what we found about Kevin Yurick, and like I said, we're fortunate to have people who care deeply who care about our family, and they're willing to spend their own money, their own time, their own resources, because otherwise we don't have anything else. We're not a family who has a lot of money and can afford resources. And over these past 24 years, we see Kevin Yurick. He has the resources of just the whole state of Maryland. Anything that he wants to do, he can do. And there's no accountability. And it's not just in this case. So just to briefly show misconduct by Kevin Yurick in other cases. So Kevin Yurick, he worked as a prosecutor in Baltimore City from 1988 to 2002. Many of his cases involved allegations and evidence of prosecutorial misconduct. So Yurick was involved in a Baltimore case in which an appellate judge ruled that a police officer improperly induced a statement from a witness who was questioned about a murder in 2000. The officer had promised down the line he would see what Yurick can do about pending robbery charges against the person. Kevin Yurick, he prosecuted a 2001 murder case in which the defendant was acquitted of all felony charges. And the defendant was a homeless and mentally ill person with Parkinson's disease. And the defense was able to successfully argue that Yurick misled the grand jury to make it appear that the defendant matched descriptions of suspect from witnesses, all the while his clothing and his physical description did not. So, and finally in 1997, Kevin Yurick, he obtained 2 murder convictions against the defendant, even though a witness testified in this case that the defendant was not the shooter. Yurick improperly impeached the witness's credibility by mentioning unrelated criminal charges against him that did not result in convictions. He also falsely implied to the jury that a state's witness had voluntarily cooperated when in fact she had been compelled to testify through a bench warrant. And these are all things that have happened in this case, that have happened in my case. So this is while he was in the Baltimore City State's Attorney's Office. But there are even more egregious examples. He moves on to become a state's attorney in Cecil County. So Kevin Yurick, he did something. He worked in Cecil County State's Attorney's Office from 2005 to 2018. And at the same time, he also maintained a private practice, which posed additional ethical problems. So in 2015, Yurick, he prosecutes a homicide case. And during the trial, he rests his case. And the defense submits a motion for judgment of acquittal due to lack of evidence. And this is one of the most rarest motions that's ever granted. Because in front of a jury, a judge will almost always say, the state has presented their case, it's up to the jury. In order to bring the most serious charge against someone, a murder charge, which carries up to the death penalty or a life sentence, surely there must be some standard of evidence that must be brought. In this case, the judge agreed for the judgment of acquittal, which is extremely rare, and acquitted the defendant of first-degree murder, second-degree murder, armed robbery, and first-degree assault halfway through the trial. And this next example is quite possibly just the most egregious ever. So in 2009, a defendant was being prosecuted in a shooting case by the Cecil County State's Attorney's Office, in which there were allegedly 2 victims. And at the same time, Kevin Yurick was representing the 2 victims, filing a monetary civil suit against the defendant. And this information was never shared with the defense or the court. And in 2019, the Court of Special Appeals overturned that conviction, finding the non-disclosure was a Brady violation. And that defendant was never tried again. So Kevin Yurick is the Cecil County State's Attorney. The State's Attorney's Office, they're prosecuting someone for allegedly shooting 2 people, and at the same time, Kevin Yurick has filed a civil suit on behalf of these 2 individuals against the defendant. And it's a multi-million-dollar civil suit. So he stands to benefit hundreds of thousands of dollars, personally himself, to get his third if this defendant is convicted at the criminal trial and at the civil trial. So just for the record, so you guys can see the actual case. And we have the names of the other cases that I mentioned. But this one so the name of the case is William Lewis Krantz versus State of Maryland. So this is an unreported opinion from the Court of Special Appeals. So if you look at the highlighted portion, it says, a civil action against Krantz seeking damages for the assault in excess of $1 million. So if you go again, they were represented in that civil action by Assistant State's Attorney Kevin Urick. So this is the opinion from the court overturning that gentleman's conviction. So the last page, Duggo, is the conclusion, where it says, in this post-conviction proceeding, we have concluded that the Brady violation was of sufficient materiality to undermine our confidence in the outcome of Krantz's trial. And we reverse the convictions and to conduct a new trial. So now, not just in Baltimore City, but all these years later, he's done what he's done in my case, and it's been presented, and it's been documented, and there's never been accountability. Now in Cecil County, all these years later, some person is convicted of a crime, and it takes 10 years for this person to prove that this Brady violation occurred in his case, and he was never tried again. So this person loses 10 years of their life, all because of Kevin Urick's Brady violation and anything else that may have happened, and they never try him again. So in 2014, Kevin Urick, he ran unsuccessfully for a Cecil County Circuit Court judge, and in the campaign finance reports showed that 3 of his 4 top donors had business before the Cecil County Circuit Court, before, during, or after they contributed to Urick's campaign, which presents a potential conflict of interest. So he's running for a judgeship, and there are several people, 3 or 4 of the donors that he solicited money from, they have business in front of the very court that he's running to be a judge, and he never discloses this in his campaign disclosures. There have been multiple instances of prosecutorial misconduct in Kevin Urick's career, whether it was at the Baltimore City State's Attorney's Office or the Cecil County State's Attorney's Office. He engages in a pattern and practice of committing Brady violations, presenting witnesses under the false guise of testifying with no benefit to themselves, and engaging in unethical tactics to discredit those defense witnesses. So this is a pattern of behavior that's occurred with him for his entire career, and there's never been a single moment of accountability, not one time. And the harm that occurs is to families like us. It's to my mom, to my little brother, who was 9 years old when he had to watch his older brother get taken out in handcuffs. And my father, who was healthy when I left home, but now he doesn't even recognize me sometimes. He can't even talk. But Kevin Urick is allowed to do these things to families like us, and there's no accountability. There's no accountability. So now we're going to move on to the misconduct of Miss Kathleen Murphy. Kathleen Murphy was Kevin Urick, was the co-prosecutor in this original case. And she continues to work to do stuff behind the scenes with regards to this case. So she worked in the Baltimore City State's Attorney's Office from 1995 to 2000. Then she worked in the Maryland Attorney General's Office from 2000 to 2004. Then she went to work in the Baltimore City State's Attorney's Office. She went back from 2004 to 2014. Then she went to work in the Carroll County State's Attorney's Office from 2014 to 2016. Then she went to work in the Maryland Attorney General's Office from 2016 to 2022. And then she was appointed as a Baltimore County District Court judge by Governor Larry Hogan on September 2nd, 2022. So just to give a little bit of background of exactly what happened in this case, the events that involve her recently. So on September 14th, 2022, the Baltimore City State's Attorney's Office and the Maryland Office of the Public Defender and the University of Baltimore School of Law Innocence Project Clinic, they filed a joint motion to vacate my conviction. And a hearing was set in Baltimore City Circuit Court for September 19th, 2022. The judge orders that my conviction be vacated and that I'm released on home detention pending results of DNA testing. In October of 2022, the charges were dismissed based on DNA results excluding me. So subsequently, so almost immediately at the same time and after that, So for all these years, we've always pushed for DNA testing. We've always had to fight the state's attorneys, fight the other side. In so many wrongful conviction cases, there's opposition to DNA testing. When the Attorney General's office, the previous administration, offered me a plea deal in secret in 2018, I rejected that plea deal after talking to my family, because we knew that if I was to accept responsibility for a crime I didn't commit for this crime, we would never get justice for Hae. And to this day, the person or persons who's responsible for Hae's murder has never served one single day in prison being held accountable for it. So to come back to this motion, so we have the utmost respect for Hae and her family for whatever they choose to do or don't do. We'll always support them, and we always just want the best for them because we want them to have justice, because we know what it's like, especially when it comes to Hae's younger brother, because we have a younger brother who was 9 years old when he had to watch his brother being taken out in handcuffs. And for the next 24 years, the only way he could see his brother was in a prison visiting room. So we have the utmost respect and concern and support for Hae's younger brother because we know what this younger brother went through. So to go through briefly what, excuse me, so Assistant State's Attorney Ms. Feldman, she was the one who was conducting this case on behalf of the State's Attorney's Office. So this is just a series of communications between her and Young Lee. These are publicly available. They were included in the motion, in the series of motions filed to the Supreme Court and the Appellate Court of Maryland. So Ms. Feldman, she reaches out, she says, okay, thank you, Your Honor. Sorry, this is the, this is the transcript of the hearing. So, okay, thank you, Your Honor. I contacted Mr. Lee by telephone on the 12th. And she says, and then I provided and let him know what was happening, what information we had developed. I went through the motion a bit with him, and I sent him a copy of the motion that day. And then the motion was filed on the 14th of September. So what comes next is the communications between Ms. Feldman and Young Lee. To be clear, and Young Lee, which we perfectly understand, his family has spent the past 24 years being told by Kathleen Murphy and Kevin Yerrick that they've blamed me for what happened to Hae, that they've falsely given me the blame for what happened to his sister. So we completely understand how they feel. We completely understand that. So Young Lee responds, to be clear, as a family, we disagree with your course of action and stand against the motion to vacate judgment. We believe that there is overwhelming evidence and that the court convicted the right person. He says, continues, I hope you understand the emotional turbulence this trial is causing us. It seems that there is never an end to it, but we understand your position as an attorney to do due diligence and cover all possibilities. So Ms. Feldman, she responds, thank you again for contacting me today. Again, I am sorry that it is under these circumstances. Attached is a draft of the motion that we are likely filing tomorrow. The motion outlines the information we uncovered about the alternative suspects. I am happy to share with you the status of the investigation as we move forward. Of course, if you have any questions, please do not hesitate to reach out to me at any time. So it goes on briefly. Mr. Young's brother responds, this is to Young Lee. The court just scheduled an in-person hearing for Monday, September 19th at 2:00 p.m. It's an in-person hearing, but I asked the court for permission for you and your family to watch the proceedings virtually, if you would like. So if you would like to watch, the link is below. Please let me know if anybody from your family will be joining the link, so I will make sure that the court lets you into the virtual courtroom. And then she says, please let me know if you have any questions. So she ends up responding, I very much understand your family's position. I'm so sorry for the pain it is causing you. I promise to keep you updated with all new developments. In the meantime, please don't hesitate to reach out with any questions. And at the bottom, he says, thank you for the email. And then this is a text message between Ms. Feldman and Young Lee the day before the hearing. And she writes, hi, Mr. Lee, it's Becky Feldman from the State's Attorney's Office. Just wanted to make sure you got my email about the hearing schedule for tomorrow. I sent a video link in case you want to watch. So he responds, hi, Mrs. Feldman. Yes, I got the email. I will be joining. Thank you. And it's important to note this was September 18th at 4:25 p.m. This was the day before the hearing. So just briefly, there's been a lot of discussion about the hearing being conducted at a fast pace and whether or not that was fair to Hae's family. And we appreciate that discussion, and we respect that. It's just that we will hope that people would consider what this has done to our family, that there are two families involved here. And this idea that's been put forward that by the other side, that the parties involved set a hearing date up soon, was to cause harm to Hae's family. It couldn't be farther from the truth. It's a completely false argument, because never consideration is given to the fact that maybe these hearings were scheduled out of concern for our family, for my mom, for my little brother, for my dad, because at this time I was incarcerated. I was in prison. And as people may know, I mean, I was incarcerated in maximum security prisons throughout my entire prison time. And the level of violence there, with COVID, with assaults, with stabbings, every single day in prison, and you could ask my mom this, they have no idea what's going to happen to me the next day. They have no idea if it's Monday, am I going to be alive on Tuesday? Am I going to be alive on Wednesday? And for years, this has hurt them so much that my mother would stay awake at nighttime. My younger brother, when he was little, he would tell me, man, I heard Mom crying last night. Because every single day is a nightmare for her. So this idea that's being put forward that this hearing was held to spite Hae's family and to spite young Lee is completely false. And no one would consider that perhaps the reason why this hearing was held quickly was because to respect my family and their suffering. And the fact that any single day that a person is in prison could be their last day in prison. So how much longer should my mom have to cry herself to sleep at night? How many days is fair to her? How many days is fair to my younger brother, worried that if he turns on the news, he's going to hear that something happened to me? So to go to this point to go back to this, that on the 18th, the day before the hearing, young Lee had told Ms. Feldman, yes, I got the email, I will be joining, thank you. So it's important, that was 4:25 p.m. The hearing is the next day. So what we've come to find out, and why that's so important, is that sometime between September 12th and September 19th, Kathleen Murphy, she had secretly made contact with young Lee. She's working at the Attorney General's office. She should have no involvement in this case. This case is alleging prosecutorial misconduct at the hands of Kevin Urich and Kathleen Murphy. So she's not supposed to be involved in this case at this point. So she has a series of conversations with young Lee, and she begins secretly calling around law firms and lawyers, looking for someone to represent young Lee and to file a challenge based on notification. So one of the law firms that she contacts is called Silverman, Thompson, Slutkin, and White. And she asks them for representation, and they refer her to Stephen Kelly. Mind you, this is secret, behind the scenes. None of this has ever been made public before. Stephen Kelly, he shows up at this hearing on Monday, September 19th, with a whole motion ready to challenge the vacature based on notification. And Stephen Kelly informs the court, I was retained in this matter at approximately 6 p.m. yesterday. So between 4:25 p.m., when young Lee says he's going to attend the hearing, now he says he was retained at 6 p.m., and within the course of a few hours, he's able to come to court with this whole entire motion prepared. So a significant amount of this information comes from The Intercept. Recently, they published an article a few weeks ago. And in this article, it says it was around this time, actually it was published, on August 19th, 2023. And it was around this time that the motion to vacate was filed, that a former associate of the Attorney General, a previous Attorney General, intervened. Kathleen Murphy had first prosecuted the Syed case in 1999 in her past role in the state's attorney's office. Last September, Governor Hogan appointed Murphy to be a judge at the Baltimore County District Court. So there are specific rules regarding how judges should or should not interact in courts with regards to cases. So she's not just working at the Attorney General's office, but she's also been appointed as a judge. So after the appointment, but before she joined the bench, Murphy became involved again in the Syed case, but not in her official capacity. She placed a call to Steve Silverman, a partner at the private law firm Silverman and Thompson, to ask for an attorney to represent Lee's family, according to Mosby, and to Silverman's partner, Brian Thompson, and another person with knowledge of the case who spoke on the condition of anonymity to discuss a pending case. So again, to go back to what Mr. Kelly says, Mr. Kelly, he tells the court at this hearing, Mr. Kelly, I was retained in this matter at approximately 6 p.m. yesterday. There's no disclosure to the court that Kathleen Murphy had contacted him. no disclosure to the court about any discussions. He's here, he knows that this is about a Brady violation committed by Kevin Yerk and in association Kathleen Murphy. And there's no disclosure whatsoever, the fact that Kathleen Murphy is the one who initially contacts him. So we get to a point in a matter of a few hours, Stephen Kelly, he prepared a motion. The idea is to believe that he prepares a motion in a matter of a few hours, and he devises a strategy that will correspond with the previous Attorney General's office in convincing the appellate court to do something completely unprecedented, to reinstate a conviction and a life sentence in a case that had been dismissed on the basis of notification. So we believe that Kathleen Murphy, she contacted Stephen Kelly, and she may have provided him with guidance on how to effectively challenge the vacature based on notification. And that she assured him, we believe that she may have assured him that the Attorney General's office would simultaneously, the previous Attorney General, would simultaneously submit filings seeking to overturn the vacature decision and to reinstate my conviction based on notification. And over the next 2 months, both Stephen Kelly, a private attorney, and the previous Attorney General's office would file a series of simultaneous corresponding motions. And these motions didn't just make similar arguments, they used the exact same words, but even more importantly, they introduced Kevin Yerk's false claims onto the record. So at this time, they're trying to convince the appellate courts to take up a case to reinstate my conviction, something that's never happened before, because when the case was dismissed, the indictment was dismissed. So technically, from a legal perspective, there's no case anymore. So they're making this huge, unprecedented effort to convince the appellate court to accept the case and to ultimately reinstate my conviction. And Kathleen Murphy is at the Attorney General's office. So just to briefly go through just one motion that they filed, and just if you could pay attention to the language, it's the exact same language from the private attorney Stephen Kelly and from the previous Attorney General's office brief. So in this motion here, it was filed on October 5th by Stephen Kelly. On September 14th, 2022, the state moved to vacate Mr. Syed's conviction under Criminal Procedure 8 subsection 301.1, alleging newly discovered evidence and the discovery of 2 alternative suspects. He continues, the state did not notify the Lee family of its intent to move to vacate the judgment until Monday, September 12, 2022. Even then, the state did not disclose any details of its investigation or the identity of the 2 new suspects to the Lee family. 2 days after the state's motion was filed, Assistant State's Attorney Becky K. Feldman sent an email to young Lee that if his family wished to watch the proceedings, they could do so via Zoom. She did not tell Mr. Lee that he had a right to participate in the hearing. Mr. Lee wished to attend the hearing in person, but could not travel from California in such short notice. He retained undersigned counsel and moved to postpone the hearing by 7 days. At the hearing on Monday, September 19th, the Honorable Melissa Finn heard arguments from undersigned counsel and denied the motion to postpone, ruling that the notice to Mr. Lee complied with all statutory and constitutional obligations to victims. Based upon a proffer from the state, the court granted the motion to vacate Syed's conviction and ordered that Mr. Syed be immediately released. On September 28, 2022, Mr. Lee filed a notice of appeal to the Court of Special Appeals pursuant to Criminal Procedure 11-103, which provides victims the right to appeal a final order that denies or fails to consider a right secured by the victim by Maryland law. On September 29, 2022, Mr. Lee filed a motion to the Circuit Court for Baltimore City asking the court to stay all proceedings pending appeal. As of this filing, the Circuit Court has not ruled on the motion. Argument in support of the state's motion. A circuit court's right to exercise its fundamental jurisdiction over a criminal case may be interrupted by a stay granted by an appellate court or the trial court itself, in those cases where a permitted appeal is taken from an interlocutory or final judgment. Pulley v. State. Because the circuit court in this case has not entered a stay of the proceedings, the court should order a stay to preserve its appellate jurisdiction. Mr. Lee has the right to appeal the state's failure to provide him reasonable notice of the motion to vacate and the state's failure to comply with the Maryland Declaration. And the footnote, a copy of the motion filed in the circuit court is appended to this motion as Exhibit 1. And it closes. Request that this court enter a stay of all proceedings in case number 1991-03042-46 pending the resolution of this appeal. Oh, thank you. I appreciate it, sir. Thank you so much. So, and that's how, thank you again, sir, and that's how the brief concludes. So, I'm not going to read through the whole next brief, but it says it's the exact same wording. This is from the Attorney General's office, and this was filed October 7th. So October 5th, Stephen Kelly files a brief, and then 2 days later, the former Attorney General's office, they file the exact same brief with the exact same language. It's not even similar language; it's the exact same language. So on September 14th, 2022, the Baltimore City State's Attorney's Office moved to vacate Syed's conviction under Criminal Procedure 8-301. So just for the sake of time, all these highlighted portions are the exact same language. It's basically, it's as if someone cut and pasted Stephen Kelly's brief and used the exact same language throughout it. It's the exact same language. And we come to the conclusion, which is the exact same conclusion. So that brief was submitted by Stephen Kelly. This brief was submitted by the previous administration, the Attorney General's office. So the next thing I want to point to is, if you remember, I said they didn't just use the same briefs. They both introduced Kevin Urick's lies about this Brady violation note to the court. So now Kevin Urick never provided an affidavit to the court. He never provided something that he could be challenged on. What he does is he leaks the information to the media, and then Stephen Kelly and the previous administration, they use his information, they use that news article to make arguments to the court that this case needs to be heard because, oh, by the way, it wasn't even really a Brady violation. So now they've created this backdoor channel to get information in front of the court without it being properly challenged. So this is from Stephen Kelly. This is from the Attorney General's brief, the previous Attorney General's office brief, and it's just very brief. It says, remarkably, the state's attorney's office did not even speak with Kevin Urick, the author of the note, upon which the allegation of the egregious Brady violation, and now it's in quotes as if it's not a real Brady violation, is based. Given that the notes were difficult to read because the handwriting is so poor and are subject to multiple interpretations, it's hard to imagine how anyone could conduct a neutral and unbiased investigation without asking Mr. Urick for his recollections surrounding the notes, or at least to interpret his own handwriting. So the brief that Stephen Kelly files incorporates this language even more. If the relevant Brady violation is the document referenced in the state's motion to vacate, it must be noted that the trial prosecutor, the author of the note, contests the interpretation the state offered to justify vacature. So he contests it not in an affidavit, not in sworn testimony. He contests it in a leak to a newspaper article. So now they've essentially weaponized this newspaper article to make an argument to the appellate court to reinstate my conviction, partially due to the fact that, oh, this wasn't even a Brady violation. So what we know is that Ms. Murphy had a series of conversations with young Lee prior to the September 19th, 2022 vacature hearing. And we know that there is a documented pattern of both Kathleen Murphy and Kevin Urick's history of misconduct in this case, convincing witnesses not to attend hearings and weaponizing their absence. And additionally, secretly procuring attorneys willing to mislead the court without disclosing that information to the court or the defense. So we know that in 2012, Kevin Urick, he manipulated Asia McClain into not attending the post-conviction hearing. And Kathleen Murphy weaponized her absence by eliciting false testimony from Kevin Urick at that hearing. And so to go to the point of them hiring attorneys or retaining attorneys for people that either defendants or witnesses in cases that they're conducting, they know how to find the right kind of attorney. They know how to find an attorney who is willing to mislead the court, provide misleading evidence to the court to further their interests. And during the initial trial in 2000, it was revealed that Kevin Urick had secured an attorney for Jay Wilds. And this was never disclosed, not in the first trial. So we had a whole first trial. This attorney was there, and it was presented as if she was just a pro bono attorney. And it was never disclosed until Jay Wilds accidentally revealed it himself on the stand. And Jay Wilds' attorney will go on and present false and misleading arguments to the court during subsequent hearings for Jay Wilds. So to go back real quick to what Asia McClain said, Urick, he discussed the evidence of this case in a manner that seemed designed to get me to think Syed was guilty and that I should not bother participating in the case. Urick convinced me into believing that I should not participate in any ongoing proceedings. So to go back real quick to what Kevin Urick said at the court. So a witness is convinced not to come to a hearing, and her absence is weaponized. A young lady named Asia McLean calls me, and what did she say? She was concerned because she was being asked questions about an affidavit she had written back at the time of the trial. She told me that she had only written it because she was getting pressure from the family, and she basically wrote it to please them and get them off her back. So the witness is convinced not to come, and then their absence is weaponized by Kathleen Murphy and Kevin Urick, ultimately to the harm of our family, to the harm of myself and our family. So to go back to the point of them securing lawyers, because there's two things here. They discourage they essentially engage in tampering with the witness, and now they're securing attorneys to benefit themselves in these proceedings. So this is from the transcript in 2000 when Jay Wilds is testifying, and he's being cross-examined. And if you look closely, Kevin Urick, he objects to this line of questioning. He says, I object. It's not the highlighted portion, it's above it. So Ms. Gutierrez, who was my trial attorney, she asked the question to Jay, did anyone help provide you with a lawyer? Kevin Urick, he objects again. The court overrules it. And Mr. Wilds says, yes, ma'am. Ms. Gutierrez asks, well, who? Mr. Wilds says, Mr. Urick. So my lawyer says, Mr. Urick, the prosecutor in this case, helped provide you a lawyer? And Jay Wilds responds, yes, ma'am. And she asked the question, was that before or after you got notice that you would be charged by him? And Kevin Urick objects. He doesn't want this information to come out. And the court overrules it, and Jay Wilds says before. So Jay Wilds was secured an attorney by Kevin Urick before he was ever even charged in this case. So what kind of attorney is this? Meaning, not what kind of attorney, but the nature of the attorneys that they choose and they seek out. They seek out attorneys who are willing to mislead the court to their benefit. So to be clear, this is Jay Wilds' plea deal hearing. This is in 1999. And if you look at the bottom where it says appearances, it says Anna Benaroya on behalf of the defendant. So this is his attorney that Kevin Urick secured for her. This is the attorney that through the first trial, it was never disclosed that Kevin Urick secured her for Jay. Through the second trial, it was never disclosed until Jay accidentally discloses it. So now Ms. Benaroya is at this hearing where Jay Wilds is pleading guilty. The case is called on the record, State versus Jay Wilds. Pursuant to a plea agreement, the defendant is to enter a plea agreement in one count of accessory after the fact of murder at this time. So it's Jay Wilds' plea hearing. He's pleading guilty to accessory to murder after the fact. And Mr. Urick says, and be sentenced pursuant to that plea agreement. Ms. Benaroya, good morning, Judge McCurdy. Anna Benaroya on behalf of Mr. Wilds. And then the court asks a series of questions. So to be clear, it's Jay Wilds' plea hearing. She entered her appearance. She goes on the record entering her appearance. So she's clearly at this hearing. She knows Jay is pleading guilty. And what ends up happening is that he ends up being sentenced. So if you look, this is essentially a court record or like a criminal record type of thing. So the defendant's name, Jay Wilds. Accessory to murder after the fact. He pleads guilty. And it was adjudicated July 6th in 2000. He pled guilty and he was sentenced. So there's no disputing this information. Jay Wilds now has a criminal record. As of 2000, he has a criminal record. Ms. Benaroya was his lawyer at the hearing. She knows this. Everyone knows this. So subsequent to this, Jay Wilds, he gets arrested and he gets charged with a series of crimes. One of them is drug possession. One of them is whatever it was. So this is a few months after this plea hearing. And then a few months after that, he goes to court. Now it's November 9th, 2001. This is a new case. This is the case I was just referring to. So on behalf of the state, Ms. Jennifer Raines, she's the prosecutor. On behalf of the defendant, Anna Benaroya. So again, she's in court for a plea deal hearing for Jay. Ms. Raines, the prosecutor. The next case is the state versus Jay Wilds. Ms. Benaroya, good morning, Judge. For the record, Anna Benaroya on behalf of Jay Wilds. So this is where the actual colloquy takes place between the judge and the lawyers. The court, what kind of a record does he have? Has he got anything? Ms. Hutchins, whom I believe is probably a court clerk, she says we do not have a copy of his record. So Ms. Raines, the prosecutor, says, I apologize. It's my understanding he does not have a criminal record. Is that correct? And Ms. Benaroya says, yes. The judge goes on. Apparently, he has no prior record. He can get his license back as well, and he gets probation before judgment. So Jay Wilds pled guilty to accessory to murder after the fact in a hearing a few months before this. Anna Benaroya was his attorney. She was there. She was secured by Kevin Urich. And just a few months later, he's back in court on another charge in which they don't have a copy of his criminal record. They say that she doesn't have a record, and Miss Benaroya, essentially, she misleads the court into thinking Jay has no criminal record. It's only a few months later. Now, what's the importance of this? This is the kind of attorney that Kathleen Murphy and Kevin Urich, when they need an attorney to represent their interests, this is who they go after. So now we come to Mr. Stephen Kelly. So as many people have been aware, Mr. Stephen Kelly has done a significant amount of media interviews with online media, with television media, with print media, any single opportunity, well, many opportunities that he's had to do media, he's done this. He's submitted multiple briefs to the court. And in these briefs, he says, and in his interviews, this is characterized as interviews, fundamental to the American justice system is the presumption of open courts, including transparent proceedings where the evidence is publicly aired. The Baltimore City State's attorney and circuit court ran roughshod over these principles by secretly collaborating to choreograph a vacatur of Mr. Syed's convictions. He continues in another brief. In sum, prosecutors set up a secretive star chamber proceeding. So throughout this entire past year, he's gone on and on, casting aspersions and slandering the character of the Baltimore City Circuit Court judge, the Baltimore City State's Attorney's Office, my attorney, the Office of the Public Defender, the Innocence Project, of engaging in a secret collaboration with no transparency. Yet from the beginning, he was in communication with Kathleen Murphy and never once disclosed this to the court. Not one time. She never disclosed it. He never disclosed it. The previous Attorney General's office never disclosed any of this information because it's a certain type of attorney that Kevin Urich and Kathleen Murphy, when they need someone to handle their best interest in a case, they go find that certain type of attorney. So throughout this appellate process, from 1999 to now, well, 2000 when I was convicted to now, Kathleen Murphy, she's always been at the agency charged with responding or handling of the appeal. In 2010 and 2012, during the post-conviction petition, she was at the Baltimore City State's Attorney's Office. So she was able to defend the conviction almost 13 years later that her and Kevin Urich got. So it's never been about securing justice. It's always been about securing this conviction. And in 2016 to 2019, this is when this case generated a tremendous amount of attention. This is where on multiple occasions judges wrote opinions vacating my conviction and saying I should be granted a new trial. She was at the Maryland Attorney General's office. And so many people, they would write letters or ask questions. Why was the Attorney General's office, the previous administration, they were never willing to consider new information or new evidence coming to light? Why were they so intent on securing this conviction as opposed to conducting an objective examination of new information or evidence? So many people were presenting information, they were uncovering things, and the previous Attorney General's office, whose job we would assume is supposed to secure justice for Maryland families, it wasn't doing that. It was intent on securing this conviction. And even to the point where in 2016, the previous Attorney General's office did something that had never been done before to so many lawyers who've said this in Maryland history. The purview of the city state's attorney's offices or local is the circuit court. The purview of the Attorney General's office is the appellate courts. You will never see a state's attorney from a local state's attorney's office arguing a case in the appellate courts. You'll just never see it. And you'll never see the Attorney General's office come into the circuit court to argue a case. To the best of my knowledge and with multiple lawyers, it's never happened in Maryland. But the Attorney General's office came into the circuit court to fight this case, the previous Attorney General's office. And even to the point where in 2018, it was the first time we were able to convince the state to do DNA testing. My attorney, Justin Brown, at the time, he had made a strong push for almost 2 or 3 years. The University of Virginia Law School Innocence Project, the director is a wonderful person named Miss Deirdre Enright. Her and her students had looked at this case, and they had found that the physical evidence recovery kit recovered from where Hae was recovered from the site had never been tested. So that's when we began pushing for DNA testing. And what ended up happening was in 2018, the Attorney General at the time, he offered me a secret plea deal. They conducted DNA testing in secret, and he offered me a plea deal, and the plea deal was that if I plead guilty, I'd be able to come home in a few years. And the conditions of this plea deal and the DNA testing was that neither me nor my attorney could publicly say anything about this. And if anyone may or may not remember, from 2016 to 2019, there was a tremendous amount of media attention on this case. Anytime someone went to court, anytime someone did anything, there was coverage. And the previous Attorney General's office was given multiple statements. They would issue multiple proclamations denying the fact that I was innocent and working hard to secure this conviction. But secretly, behind the scenes, I was being offered this plea deal. So we couldn't understand what was this behavior based on. And even in 2022, a joint DNA petition was filed. The AG's office, unbeknownst to many people, the previous administration, they filed a motion which was essentially arguing to convince the judge not to grant the joint DNA petition. And we definitely couldn't understand that, because how in the world would you be opposed to testing evidence using new DNA methods that had just been developed in the past few years? How in the world would you want to convince a judge to not allow this testing? So we could never figure this out until just recently we got this email. And this email is from Ms. Carrie Williams, who is the Deputy Attorney General, and it's from March 2022. And it's sent to Mr. Brian Frosch, but more importantly, it's sent to Ms. Kathleen Murphy. And it's a statement to supplement the record. It's filed. So it says, "Good afternoon. I just filed a statement to supplement the record. A stamped copy is attached. I'm going to email a courtesy copy to the Baltimore City State's Attorney's Office and Defense Counsel in a bit. Hard copies will also be mailed today. Have a good weekend. Carrie." So this is the follow-up to that email. It's from her to Brian Frosch, again, Kathleen Murphy. And so I've redacted a few names, and I'll explain why in a second. Kathleen Murphy. The response, well, it's a thank you, sorry, if you look, and then it says, "My pleasure, have a good weekend." So even sending that, it's being sent to Kathleen Murphy also. So if you go down, it's just a repeat of the email. But the point is, the question is, why is she being included in these emails when she has nothing to do with the case? How in the world can the prosecutor, who we're alleging committed misconduct, be involved in essentially the organization that's supposed to objectively examine all these claims? So to real quickly, just to look through the statement to supplement the record, this was the supplement that was submitted, and many people don't know about this, to the judge who ultimately granted post-conviction DNA testing. And this supplement was meant to, what we believe it was meant to, and is framed to convince the judge not to allow DNA testing. So it says, Syed's DNA was not found on any of the items tested. Only the victim's DNA and one unidentified female DNA profile were recovered. This was already known. The joint motion already talked about the DNA testing that had been done, and it had been done using old methods. We wanted to conduct DNA testing with new methods. So she continues, and the way the previous administration and the Attorney Generals, this is how they described the case to the judge. The background of the case. In 2000, I was convicted in circuit court, and if you look at the highlighted portion, in summary, in 2014, the court denied post-conviction relief to Syed. And it just says who filed an application for leave to appeal the denial since then, and it just continues. But then it closes out by saying prior to the joint motion, the last state filing was OAG's opposition to Syed's petition for writ of certiorari in the U.S. Supreme Court, which was denied on September 25th. So they would have the judge believe that I was convicted, an appeal was denied, and then something else was denied again. No mention of the multiple times, no mention of the new evidence that's come to light, no evidence of the multiple times courts had ordered hearings in this case, courts have granted me a new trial, witnesses have come forward. There's no mention of it in the background. It's as if to present to the judge, well, he got convicted and then that's it. Nothing else happened in between. So now we move on to where these emails come from. And the reason why I redacted some names, as I said before, we're fortunate to have so many people who they care about justice for Hae, they care about my family, they believe that I'm innocent, or at the very least I didn't receive a fair trial. And over the past several months, people have been filing Public Information Act requests to the Attorney General's office. And I want to specifically read, so the names that I've redacted are the people who filed these motions, these petitions, and the people in the Attorney General's office, the new administration, who have responded, because they have nothing to do with the case. I just want to protect their identities. So just real quick, it says, The Maryland Public Information Act, this is the request, this is a response to the request. Any and all written, the request was for any and all written communications from former Assistant Attorney General Kathleen Murphy to Young Lee, to Stephen Kelly, to David Sanford, Ari Rubin, Deborah Marcuse, Brian Frosch, and Kerry Williams from September 10th through September 30th, 2022, regarding Adnan Syed, Syed case, Hae Min Lee, the vacature, September 19th, 2022 hearing, victim representation, or victim notification. And at the bottom, it's something is so important. We have identified additional emails and attachments responsive to your requests, but these records are not subject to disclosure. So the only email that was received was the one from Ms. Williams to both Brian Frosch, and which shows Kathleen Murphy is attached to these emails. So we feel that this email shows that Kathleen Murphy has been included in the discussions about the responses and strategy regarding any appellate claims that me and our attorneys and our family have filed. That even when the state's attorney's office was filing a joint motion for DNA testing, that she was able to use the support of the previous attorney general's office in an attempt to convince the judge that DNA testing was not necessary, all under the guise of correcting the record. We believe that Ms. Murphy has been orchestrating behind the scenes to protect herself and Kevin Urich from accountability. We believe that she's managed to convince the previous Attorney General's office to oppose every single motion we filed from 2016 to 2022 and to ignore and dispute any piece of new evidence or information that's come to light which would question the integrity of this conviction. And we believe that we can provide that. We have provided and there's evidence for that. So we move on to what our family's request is to Mr. Attorney General Brown. So to be clear, all of this stuff happened in the old administration. In the old administration. None of this stuff happened under Mr. Anthony Brown. Not one single bit of it. So our family is asking the Attorney General to open an investigation into Kevin Urich and Kathleen Murphy's prosecutorial misconduct. We're asking for the scope of investigation to include Urich's withholding of evidence from the state cell tower expert in 2000. We're asking, number two, that the scope includes Urich's witness tampering and discouraging Asia McClain from attending the 2012 post-conviction hearing and then providing false testimony at the hearing. And that we're asking to investigate Urich's latest Brady violation, which was discovered only in 2022, concerning the note containing information about an individual threatening to kill Hae. We're asking that he investigate Urich's leaking of information to the local media and the evidence tampering he has engaged in regarding the above note, the altering the meaning of the note and creating a false transcript. And if you look up the definition, the legal definition of evidence tampering, it describes any altering or fabrication, anything to do with evidence with the intent to mislead an investigation or a hearing. And we would argue that Kevin Urich, when he leaked this note, it was part of a strategy that he would leak this information, and this information would find its way in front of the court via these motions that were filed by the previous administration and Stephen Kelly. We would also ask that Mr. Brown assign someone to investigate Kathleen Murphy's actions during the 2012 post-conviction hearing. And was she aware of Kevin Urich's witness tampering with Asia McClain and the fact that his testimony has proven to be false? And when did Ms. Murphy first make contact with Young Lee prior to the September 19, 2022 vacature proceeding regarding that hearing? And what was the content of those conversations with Young Lee? Did Ms. Murphy do anything to discourage Young Lee from attending the hearing? And did Ms. Murphy encourage or discourage him regarding the hearing? When did Ms. Murphy begin contacting law firms regarding representation for Young Lee to challenge the vacature hearing? And which firms did she contact? And when did Ms. Murphy make contact with Stephen Kelly regarding providing representation for Young Lee? What was the content of those conversations with Mr. Kelly? Did she provide Kelly with instructions on how to challenge the outcome of the vacature proceeding using notification? I just want to be clear about something from the beginning. We're not asking that anyone contact or investigate or do anything with Hae's family. We're not asking for anyone to have a conversation with Hae's family about any of this. They've suffered so much over the past 24 years. We don't want them to suffer anymore. We're only asking that Ms. Murphy, Mr. Urich, and Mr. Kelly, that they be questioned. We absolutely respect Hae's family's right to have their privacy, and we're absolutely saying they did nothing wrong in this proceeding. Absolutely nothing wrong. We support whatever they want to do. And our goal has always been to help them get justice for my friend Hae and for her family. So I say all these things because, to move on to the 11th thing we're asking, did Ms. Murphy promise Kelly that she would convince the Attorney General's office to support the motions that he would be filing? Was Murphy involved in discussions and or strategizing at the Attorney General's office regarding responses to and challenging the September 22 vacature proceeding? Was Ms. Murphy involved with the discussions and or strategizing at the Attorney General's office regarding the response to the 2022 joint filing of the motion for post-conviction testing? And what was the extent of Ms. Murphy's involvement in the discussions and or strategizing at the Attorney General's office regarding appeals in the Syed case between 2016 and 2022? We're asking that he look into those emails that can't be disclosed. We're asking that he look into communications that can't be disclosed. We're asking that he interview the Deputy Attorney Generals who were filing motions in this case about what their discussions were with Kathleen Murphy regarding strategizing. And then finally, we're asking that this investigation should include questioning of Mr. Stephen Kelly. When did Kathleen Murphy contact him about representing young Lee and challenging the vacature proceeding? Did Ms. Murphy provide guidance to Kelly on how to challenge the vacature outcome using notification? Did Ms. Murphy promise Kelly that the Attorney General's office would support the motions that he would file? And why did Kelly not disclose any of this to the court? And to be clear, the reason why we're asking the Office of the Attorney General, Mr. Brown, to open an investigation, because there's no one else in the state of Maryland we can appeal to. Typically, the Attorney Grievance Commission has what's called the Office of Bar Counsel. And the Office of Bar Counsel is charged with authorizing investigations into misconduct committed by attorneys in Maryland. And currently, there is no Bar Counsel assigned in Maryland. There are new nominees being considered now by the Attorney Grievance Commission, but the selection process is slow. Additionally, the finalists selected to the post of Bar Counsel must be confirmed by the Maryland Supreme Court. The previous finalist selected by the Attorney Grievance Commission was rejected by the Maryland Supreme Court. And we can't go to the U.S. Attorney's Office, the federal government in Maryland, because that office is conflicted in any investigation of Kathleen Murphy and Kevin Urich's misconduct in this case. And the reason why they're conflicted is because Kathleen Murphy's spouse, he is currently working at the U.S. Attorney's Office in Maryland as a high-level assistant U.S. attorney. So to go briefly, these are just some headlines from some local publications about the Bar Counsel finalist says he was rejected by Maryland Supreme Court. So this is the person that we would have gone to with these complaints, with this evidence and this information. And this is from July 2023. 4 finalists named for Maryland Bar Counsel job after first nominee rejected. This is in August. It's less than a month ago. And then the Office of Bar Counsel faces staffing woes as search for new leadership stretches on. So we can't go to the Bar Counsel, essentially. There's no one there to go to. And with regards to the U.S. Attorney's Office, Kathleen Murphy's spouse, this is the U.S. Attorney's Office for the District of Maryland, and I X'd his name out just to protect his privacy, but he's listed as a U.S. attorney at that office. So that's the very definition of a conflict, I would see. How in the world can the U.S. Attorney's Office represent the spouse of one of its leading assistant U.S. attorneys? So I guess to come to the closing part is that, what is all this about? Because we're making claims and we're providing evidence that Kathleen Murphy and Kevin Urich, 24 years later, are working so hard to protect this conviction. They're working so hard to not be held accountable. They're doing all this stuff behind the scenes. And what it's all about, what we believe is this, that the state of Maryland did something, the Maryland Supreme Court did something that is extremely unique in the history of our country, in that retired Hartford State's Attorney Casilli disbarred over handling of Memorial Day murders. And this is from October 22nd, 2021. It's only 2 years ago. So just to read briefly, Maryland's highest court has disbarred retired Hartford County State's Attorney Joseph Casilli for withholding exculpatory evidence that surfaced in a 1981 double murder case and lying about it over the years. And the gentleman who was in this case, his name was Mr. John Huffington. And he's a very dear friend of our families. He's someone who's always supported us and he's believed in us. And he's just offered his help and assistance like so many other people have. So Mr. Huffington spent over 30 years in prison for a crime he didn't commit. And he was fortunate enough to have representation. They filed a grievance through the Office of the Bar Counsel And it took a while, but it's made its way to the Supreme Court. The Supreme Court reviewed all the information about Mr. Casilli, and they decided that he deserves to be disbarred. And it's one of the most rarest things that have ever happened, where a prosecutor was disbarred for committing Brady violations, for withholding exculpatory evidence and lying it over years. And we believe that that's the reason why Kathleen Murphy and Kevin Urick are continuing to this day to use their associates, to use their anyone who supports them, anyone who's their surrogates, to essentially keep this case as a conviction which harms us, which harms my mom, which causes a considerable amount of pain to my mom, to my dad, to my brother, and to me. All because they don't want to be held accountable. They don't want to be disbarred. Kathleen Murphy is currently a judge. She doesn't want to lose her judgeship. Kevin Urick is currently whatever it is that he's doing. And so we believe that, that's the reason why they're doing what they're doing, even to this day. So the last thing I'll say, and then I'll open up for questions, and I appreciate everyone. I'm so sorry that this has taken so long, but Kathleen Murphy, over the past year, Kathleen Murphy and Kevin Urick would have everyone believe that Mr. Stephen Kelly was the architect of all this, that Mr. Stephen Kelly was essentially the brains behind this completely unprecedented, just unbelievable series of events where he manages to convince an appellate court to take up a case where the indictment has been dismissed, and legally there is no case to take up. And Judge Berger, he very emphatically talked about this in his dissent opinion, that Stephen Kelly is the person who was able to convince the Attorney General's office to file the same briefs that he was filing, that he was able to convince the appellate court to do something even more unprecedented, to reinstate a life sentence, to reinstate a conviction, to reinstate my conviction, based on the issue of notification. Nothing to do with the nature of the case itself. So they would have us believe that Stephen Kelly is the one who was capable of doing that, with nothing else going on. So I just wanted to very briefly play, this is Mr. Stephen Kelly, and this is his presentation to the court. I'm just going to play about 2 minutes of it.
The appellate. So my first question is that